Kubibaddewo olwaleero olabira ddala nti nga state yeegendereddwa mu kulaba nga bonoona obudde bwaffe okuba nga batukuma mu bintu bino bitulaba nti nno tebyalimu nsawadde n'akatono kuba ekyaliwo kyonna kyonna mwakiraba nga yali politics, tewaaliwo kigendererwa kirala kuleka okutwononera obudde neera nakati kyebaliko okulaba nga batukumira mu makooti twandibadde nga tukola bintu birala nnyo. Nandibadde ndi mu palamenti ndi ku nsonga ndala nnyo, mu committees nandibadde ndi ku kitebe ndi mu nsonga ndala nnyo okulaba nga mpeereza bannamityana ne bannayuganda okutwaliza awamu, naye baagala okutukumira mu nsonga zino basale ku sipiidi yaffe kyetwagenda kukkiriza kuba ensonga zino tumanyi nti zabya bafuzi eno just persecution batuli mu kulaba nga batudaaza batubonyabonya, naye tujja kubirwana ate era bijja kuggwa mu buwanguzi. It is clear that all this is happening because of politics. They are just wasting our time. They just want to cut our speed. But as you are well aware about what happened that day, they wanted to stop us. So what's happening in court, it's just a wastage of time. But we are sure we shall follow up this to the dot and it will end in victory.
Nga tuwaayo ensonga lwaki tulowooza nti omusango guno kooti eba esaana eguweereze mu kooti entaputa ssemateeka, nga tulowooza nti emisango gye bamuvunaana egimu givvoola ennyingo ya ssemateeka egamba nti omusango gulina okubeera nga gutegeezeddwa bulungi. Omulamuzi n'atuwuliriza bw'amaze n'awandiika ensala ye n'agamba nti takkiriziganya naffe, ye mu kulaba kwalowooza nti omusango gunnyonnyolwa bulungi, era n'agamba tagenda gusindika mu kkooti entaputa ssemateeka, naye n'atuwaayo obudde okulaba oba tujulira ensala ye oba tetujulira, era n'agwongerayo paka nga 18 omwezi ogujja nti bwe tunaaba tujulidde, bwe tunaaba tutujulidde gujja kwagguulirwa. Si ekyo ekyokujulira, ekiddako tujja kusooka kutuulamu twogeremu ne client waffe tulabe ekiddako. So kyekyo kibaddewo olwaleero. Then tusabye n'emmotoka ye eyawambibwa eteebwe kubanga oludda oluwambi lwatuwadda birugenda okwesigamako okuwuliriza omusango guno ng'emmotoka teriimu, nga twalina ensonga lwaki ekyakwatibwa. Era kooti naye tugamba tukomewo ku Mande bbalaza ya wiiki ejja etuwa ensala kuba tusabye kooti w'ekiragiro emmotoka eyakwatibwa eteebwe, so tujja kuba tukifuna nti ku Mande ya wiiki ejja.
We are here again for the hearing of Zaake's case. We had applied that the court refers the matter to the Constitutional Court, but the trial chief magistrate didn't agree with us and has adjourned the case 18th December, reasoning that the traffic charges, the traffic offences are clear and are not ambiguous, and therefore they don't need interpretation. And on 18th December, we should be able to proceed with the hearing. But we also had another prayer for relating to his right to property, regarding his motor vehicle which was impounded at police and which police did not exhibit, and we requested him to order its release, and he has asked for time to reflect on that issue and rule upon the same on Monday at 10. He will give that ruling regarding whether to release the car or not. So that's in brief what transpired today.
Then for this one, there is no appeal to the fact.
Your worship, will it be?
Role of the court under Article 175 of the Constitution provides as follows.
where any question as to the interpretation of this Constitution arises in any proceedings in the court of law other than the purely court matter, the court may, if it is of the opinion that there is a question involving a substantial question of law, and shall give the party to the proceedings request it to do so, defer the question to the Constitutional Court for a decision in accordance with Clause 1 of this article. The reading of article above as a whole does not make this court a mere conveyor belt and the referral court on a mere request of an applicant. Rather, it involves the grant of this court to first give a test by way of an opinion as to whether there is a substantial question to be referred. The law does not, however, define the term substantial. However, English defines it as something of considerable importance. Hence, the land state category has the right to participate in the work submissions to the court in reaching such an opinion, if at all he thinks he or she has an opinion. Whether there is substantial question of law to be referred to the Constitutional Court, requiring interpretation in respect of Section 107 and 164 of the Road and Public Safety Act. I shall begin by quoting the few sections below for purposes of proper diagnosis of this matter. Section 107
and have the determination on their constitutionality. We also note that Article 28, Your Honor, falls among the non-derogable rights protected under Article 44C. And we would therefore pray that this court, under Article 44C of the Constitution, and therefore pray that this court stays the hearing of this case and exercises its mandate under Article 137 5B of the Constitution, 137 5B of the Constitution, to refer the same matter to the Constitutional Court upon our application for determination. The Honor will also frame the particular questions that will bring
confiscated property.
creating a criminal offense which is not well defined. Is now on the principle of void for vagueness. And further, that there is an absolute bar imposed by the Constitution against diminishing the right to a fair trial. And the purpose is to know what conduct is specifically prohibited avoid arbitrary or discriminatory enforcement. We brought that out for emphasis. Avoid arbitrary or discrimination in enforcement of that provision. You honor the same court in the case of Andrew Karamagi versus Attorney General. Andrew Karamagi and another versus Attorney General. Noted that the statute is void for court for referral to the Constitutional Court. And the questions are two questions. Whether section 107 of the Traffic and Road Safety Act, Cap 347,
Whether
section 107 of the Traffic and Road Safety Act is inconsistent with Articles 20, 28, 1, 3, and 12, and 44C of the Constitution, on the principle of legality, and therefore null and void.
Last time we one of them is the constitutional application,
elements of council seeking to see a certain interpretation of English words, and yet they can be defined by the dictionaries. In this case, I am of the opinion that the sections have clear meaning, and the only issues raised can be solved by the aid of the dictionary, which is one of the aids of certain interpretation. And then I find no questions requiring interpretation will be referred to the question of words. I declare to stay the proceedings and dismiss it for prayer. This matter will therefore proceed. However, to accord the applicant time to think of whether to appeal against this ruling, Mr. Radja in this case give him ample time to seek a remedy.